Calling the matter of Ashlee Lynn Buzzard.
We're entering a not guilty plea with no time waiver. We're requesting an assignment as quickly as possible. She has a local residence. She is not a flight risk.
And with that, a judge set Ashlee Buzzard free on bond at her arraignment today. But wait, not a flight risk? What? Ashlee Buzzard took a 3,000-mile, 3-day trip with her beautiful little daughter, Melodee, and Melodee never came home. They traveled through 5 states, and now the FBI is trying to figure out their every stop and where she left Melodee. That's a very large area to search. And consider this. It's only 249 miles to get out of the country. That's 4 hours. For a woman who likes ride shares, for less than $1,000, she could be over the border. I'm Ann Emerson, an investigative reporter with more than 30 years of experience, and I've been tracking this case very closely. Please like and subscribe so you get the latest news about what's going on. Melodee's been missing for more than a month now, and police are desperate to find her. We'll talk about the false imprisonment charge against her mother, Ashlee, in a minute, but first, listen to what the prosecutor told Judge McGregor at today's hearing.
Ms. Buzzard has been notably uncooperative with law enforcement and child welfare services. It has been found in the investigation pertaining to the disappearance of her daughter, Melodee, that she switched license plates on her rented vehicle to and from Nebraska. She wore wigs. It's apparent that she has taken lengths to conceal her identity and whereabouts on other occasions. And if she were to be released, that is a concern, on top of the fact that she is non-cooperative with law enforcement.
But the judge let her out anyway. He did order Ashlee to wear a GPS ankle monitoring bracelet. No contact with Tyler Brewer. That's the man who filed the criminal complaint against Ashlee last week. They arrested Ashlee after Tyler told police that Ashlee had held him hostage with a box cutter. Tyler said the incident at Ashlee's house escalated when she told him information that she regretted sharing. Information about her daughter? Question mark? Nobody knows because Tyler's not talking. But investigators did say that the false imprisonment charge was not related to Melodee's disappearance. And here's another question. For a woman who doesn't have a job, how is she posting bail? Ashlee's probably only had to put up about 10% of her $100,000 bail. According to the private investigator who's been speaking to us from the road, that's not necessarily an issue. She's also receiving Melodee's Social Security from when her father died when she was a baby. So here's why we believe Ashlee may well be planning to leave. We have video of her moving boxes, as well as photos of packed moving boxes inside her garage.
Looks like she may have been preparing to leave. When I first pulled up there, the garage door was open, I understand, for a long period of time, including overnight. So I was able to take a number of photographs of the interior of the garage with the garage door open from a public distance. And it looked like a number of clothing and appliances, small appliances and different items packed up and then unpacked by the initial search warrant. So it does look like she was getting ready to pack that up. But again, we don't know what her mental state was or is. And so it's hard to deduce what that was all about.
So Jackie Goodman is a criminal defense attorney. Jackie, is this suspicious behavior enough to be concerned about a flight risk?
So the judge, when he is or she is hearing a question of bail, is concerned with two things: a flight risk and danger to the community. And here's something interesting. People think that we're talking all the time about this presumption of innocence. That does not really apply at all until the jury goes into the jury room to deliberate after a trial. So for purposes of bail, the judge has to assume that the facts in the police report are true for the purposes of bail. But let's consider for a moment, what facts are we talking about? She's now charged with a false imprisonment, not with anything to do with the disappearance of her daughter. So yes, the judge takes into account all of the facts that the judge is aware of. And so she is not necessarily a suspect. We don't know what has happened to Melodee. So I mean, even if the police think she's a suspect, according to the evidence the judge has before him or her, there's really no information about Ashlee being responsible or in any way other than what we're talking about with speculation connected to the other crime. And that crime is not before this judge right now. Furthermore, the danger to the community portion of it, that is certainly something that a court is supposed to take into account and will take into account when determining what is the least restrictive means necessary in order to get this person who's at this point presumed guilty of the crime charge, that's false imprisonment of an adult momentarily, by the way. And the judge takes into account the facts underlying that crime and then takes the least restrictive measures to ensure that that person has their day in court, comes back to court, and doesn't commit any crime in the interim. And so the judge probably quite reasonably determined that a GPS device would be enough to allay any fears in that regard. Now, listen, it makes perfect sense that the public and others looking into this case are very, very concerned, and different judges might have gone differently when they look at the evidence of other concerns. But apparently that evidence is not known to me, and whatever was before that court was enough to satisfy the court that this is the least restrictive means to ensure that she appears at the future hearings.
Okay, so 2 questions. GPS monitoring for this on the ankle bracelet, is that going to be enough to get her to stay put?
Well, we're speculating about that too. Also, listen, all of the information that we have is that Ashlee Buzzard has a mental health condition, that she's got at least some behaviors that cause concern. And so whether this mechanism is enough to keep her coming back to court or to keep her in place while her case is pending is still to be known. But, she's not necessarily operating the way most people would operate. And so I'm sure they're going to keep a close look on where she is.
From what I understand, she's got to be back in court next week for pretrial hearing.
Yes.
Does that November 19th to 20th, they're talking about having her come back?
That's correct. So at the beginning of a case in California begins with an arraignment. That's your formal charging. And it's bookended with the preliminary examination. In other jurisdictions, we call that a probable cause hearing. It could also be a grand jury hearing. It's a look at what the prosecution is doing for a court, some other branch of government from the executive branch, to look over what the prosecutor is doing. Only in felony cases, defendants don't get this kind of second look at what the prosecutor is doing in misdemeanor cases. But in more serious felony cases, a defendant is entitled to this second look. The judge is not going to be pushing a jury out of the way and deciding guilt or innocence. The judge is not going to be usurping the role of the prosecutor. Simply put, the judge is looking to determine whether some evidence is before that court, which, if believed, makes up each element of the crime. So, in essence, a judge is looking at what is the correct crime under these circumstances. It's a very small amount of evidence. You've heard that grand juries will indict a ham sandwich. It's the same standard. So some evidence which, if believed, makes up each element of the crime. It's a check on, is this the correct crime, and is this defendant at least reasonably suspected of this behavior? So those two things are bookending everything that happens in between. And those things that happen in between, we refer to those court hearings as pretrials, and there can be 1 or 100 of those pretrials. And at those pretrials, there's discovery, where we include information from both sides, where we talk about that. There's negotiations between the parties, where we try to come to some understanding and agreement so that the litigation doesn't need to go forward. And then there's motions to keep out certain pieces of evidence or put in certain pieces of evidence. So those are kind of the big bucket things that happen at pretrials in between. And that's her first opportunity now to obtain the discovery, get a chance for her lawyers to look at it, and come back and have a conversation with the prosecutor on that day.
Yeah, and she's pleading not guilty. So
she has pled not guilty, yes.
Right. And so now, I guess this is the other part of it that we're kind of all trying to understand. Is there logic behind this? Well, first, why didn't they try and hold her on a mental health hold for more of an evaluation?
Understood. The standard for a mental health evaluation, or in California, it's Penal Code Section 1368, the standard to be incompetent in order to justify that kind of a hold is a very, very high standard. A person really would have to be shown to not have the capacity to understand the proceedings. You can't just decide, that person seems odd. I want them to be held as a violation, of their freedom of movement. And so when we take away someone's freedoms in that way, and we subject them to what is going to be disclosure of very sensitive information, psychiatric evaluations, that
Yes.
is something that doesn't occur without at least a lawyer the defense lawyer, making a statement to the court that they have a doubt as to the person's mental capacity or ability to understand the proceedings. So again, you can be insane and still understand that you're on trial. And so it's a really, really high standard before someone can come in and force us against our will to be held against our will and subjected to these psychiatric evaluations, and then for that to be disclosed to the court and other public entities.
I think a lot of people were hoping that while she was being held, there would be an opportunity to get more information about where her daughter is. Um, is that legally possible? Are they allowed to ask her those kind of questions if she was in jail?
Not really. Police have lots of tools at their disposal, and sometimes they do utilize these efforts to try to talk to somebody who is in custody about a different matter. And they are, in that case, taking the case in front of them, in our case, the false imprisonment, and they're saying, I'm not going to talk to you about this false imprisonment thing, but do you want to talk to me about where your daughter is? The problem with that is that if she's a suspect in the disappearance of her daughter and they suspect malfeasance in that, they're really taking chances with Miranda and the Fifth Amendment and the voluntariness of her statement in a later prosecution. Listen, law enforcement is going to take their chances in different ways. What is the goal? If the goal is to find the child and secondarily it's to prosecute the perpetrator of whatever wrongdoing occurred, then they may decide to take those opportunities and try and talk with her. But, she seems to be, at least from the reports that we're seeing, aware of her situation, aware of the jeopardy that she's in with respect to her daughter. She understands, she can read the news, she's having conversations with folks. So while she may be acting unusually, she doesn't appear to be behaving in such a way that she doesn't understand what's happening. And it's not likely, in my opinion, that she would be talking to police voluntarily about anything to do with her daughter. She's so far been uncooperative, which I think is probably one of the most damning aspects of this case.
Absolutely. Thank you so much, Jackie. That really, really helped clear up some stuff that I think people have a lot of questions about.
Always a pleasure, Anne. Thank you for having me.
As Ashlee gets released tonight, neighbors say they promise to keep us up to date with her whereabouts. They're watching to see if she comes back home. But remember, this is about finding Melodee, and only Ashlee knows the truth. Drop a comment below and tell me, do you think Ashlee should have been let out of jail? And do you think she's going to tell law enforcement where Melodee is?